Bach, Brackett, Buckner-Webb, Cameron, Davis, Durst, Fulcher, Getty, Guthrie, Hagedorn, Hyder, Hill, Johnson, Keogh, Lacey, Lakey, Lodge, Martin, McKenzie, Mortimer, Nonini, Nuxall, Patrick, Pierce, Rice, Schmidt, Sidaway, Stennett, Thane, Tippett, Vick, Work, Winder, Bach, Brackett, Davis, Johnson, Schmidt, Work,
Senator Work. Roll call shows 33 present, 2 absent excused. Senator Bach has an excused absent. Quorum of Senator Brackett will be added to the roll call for a total of 34 present and 1 absent excused. Quorum being present, the Senate will advance to the second order of business, prayer by Chaplain James Weberding and Pledge of Allegiance. We'd ask our friends in the gallery to rise and join us in prayer.
Let us pray. Holy Father, you are the creator of all good things and the ruler of all. Yet from the beginning, you gave our human family a part to play in creating and a part to play in ruling. As our good senators practice both arts, in some measure at least, again today, I pray that you will bless them. Please guide their choices and bless the outcomes. I pray in Jesus' name. Amen.
Amen. Now be led in the Pledge of Allegiance by our page, Robin Croteau. Robin.
I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Senate will advance the third order of business, reading Corrections Journal.
March 7th, 2013, the Judiciary and Rules Committee reports that the Senate Journal of the Proceedings of March 6, 2013 was read and approved as corrected. Lodge Chairman.
Report will be filed in the office of Secretary. Senator Davis.
Mr. President, personal privilege.
You have the floor.
Mr. President, Senators, our intent is to do some of the various orders of business between here and the completion of our second reading calendar, including picking up the work in the 10th order of business, the concurrent resolutions and the gubernatorial appointment. Once we have finished the work in the second reading calendar, it is our intent to skip over the 13th order of business, go straight to the 14th order, and grab the legislation that is currently in the 14th order of business for amendment. Once we have finished our work in the Committee of the Whole, we will then return to the 13th order of business and pick up the legislation in the order that it is on your calendar. Mr. President, I ask unanimous consent to advance to the 5th order of business.
Without objection, Senate advance to 5th order of business. Petitions, resolutions, and memorials. Senate's at the 5th order of business. Senator Davis.
Mr. President, I ask unanimous consent that all petitions, resolutions, and memorials be read by number, author, and title only in the journal. Show they've been read at length.
Without objection, so ordered.
In the Senate Concurrent Resolution Number 121 by State Affairs Committee, a concurrent resolution stating findings of the legislature and rejecting a certain rule docket of the Bureau of Occupational Licenses relating to the rules of Idaho Driving Businesses Licensure Board. In the Senate Concurrent Resolution Number 122 by State Affairs Committee, a concurrent resolution stating findings of the legislature and rejecting certain rules of the Bureau of Occupational Licenses relating to rules of the Board of Architectural Examiners.
Senate concurrent resolutions 121 and 122 will be referred to the Judiciary and Rules Committee for printing.
There is no further business in the fifth order, Mr. President.
Senate advances sixth order of business. Report to Standing Committee. Senate's at the sixth order of business.
March 6, 2013, the Judiciary and Rules Committee reports that Senate Concurrent Resolution 104 has been correctly enrolled. Lodge Chairman.
The President has signed Senate Concurrent Resolution 104 and will be transmitted to the House for the signature of the Speaker.
March 5, 2013, the Education Committee reports out Senate Bill 1133 with the recommendation that it be referred to the 14th Order of Business for amendment. Getty, Chairman.
Hearing no objection, Senate Bill 1133 will be referred to the 14th Order of Business for amendment.
March 6, 2013, the State Affairs Committee reports out Senate Bill 1080, Senate Bill 1108, and Senate Bill 1079 and recommend that they do pass. McKenzie, Chairman.
Senate Bills 1080 and 1108 and 1079 will all be referred to the 12th Order of Business. Second reading.
March 6, 2013, the Finance Committee reports out House Bill 233, 234, 235, 236, 237, and House Bill 238 and recommend that they do pass. Cameron, Chairman.
House Bills 233, 234, 235, 236, 237, 238 will be referred to the 12th Order of Business. Second reading.
March 6, 2013, the Education Committee reports out House Concurrent Resolution 16 and recommend that it do pass. Getty, Chairman.
House Concurrent Resolution number 16 will refer to the 10th Order of Business and held for one legislative day.
March 6, 2013, the Health and Welfare Committee reports out House Concurrent Resolution 6 and House Concurrent Resolution 10 and recommend that they do pass. Hyder, Chairman.
House Concurrent Resolutions number 6 and number 10 will be referred to the 10th Order of Business and held for one legislative day.
March 6, 2013, the Local Government and Taxation Committee reports out Senate Bill 1138 with a recommendation that it be referred to the 14th Order of Business for amendment. Sit away, Chairman.
Hearing no objection, Senate Bill 1138 will be referred to the 14th Order of Business for amendment.
March 6, 2013, the Local Government and Taxation Committee reports out House Bill 184 and House Bill 187 and recommend that they do pass. Sit away, Chairman.
House Bills 184 and 187 will be referred to the 12th Order of Business. Second reading.
There is no further business in the sixth order, Mr. President.
Senator Davis.
Mr. President, I ask unanimous consent. Senate Goody shall call the chair.
Without objection, Senate be at ease.
Mr. President, personal privilege.
You have the floor, Senator.
Thank you. I would like to take this opportunity to introduce the groups up there with the red jackets. It's Red Jacket Day today, and honoring the Republican women. And I wish they'd all stand so we can recognize them.
Mr. President.
Senator Mortimer.
Mr. President, I would also like to introduce, and they've really kind of been introduced, but I would feel really bad if I didn't introduce the Bonneville County people that have been so supportive of all of us in Bonneville County. If they would please stand one more time, I believe they're right here. Thank you.
Senator Johnson.
Thank you, Mr. President. While we're at ease, I too would be remiss if I did not introduce to you our fine constituents, red-coated ladies from Nez Perce County, Miss Carolyn Durant and Miss Sue Prang, both very good people, and help me please welcome them today. If you could wave, let them know who you are, Carolyn and Sue. Thank you. Yeah, thank you.
Senator Lodge.
I have to continue this, Mr. President, because I'm also wearing red. We have with us Julie Chatterton, who is the president of the Idaho Federation of Republican Women, and our good Canyon County ladies, and one of our past presidents, Melinda Smizer, Senator Melinda Smizer. Where are you, Melinda? She was there. And with us today, so would the ladies from Canyon County and Owyhee County please stand up? Presidents. Thank you.
Senator Getty.
I'm going to be more regional. I'd just like the ladies from North Idaho that are wearing red to please stand and have the Senate acknowledge them.
Would that include your wife, Senator?
Mr. President, it might, and you notice it is North Idaho, not Northern Idaho.
I noticed that. Further announcements? Well, the only person up there that hasn't stood up is my cousin Harry Bettis, who's up there somewhere. But I know he's enjoying it with all those good-looking women up there. So, Harry, wave at these people for me. Senator Nonini.
Thank you, Mr. President, for an introduction. Senators, help me welcome some students that are here in the gallery from Lake City High School. The good senator from Forres District, we have Dan Armstrong and Bill Kellen. And from Post Falls High School, my legislative district, Angela Blair. Please welcome them.
Senate will come to order. Prior to going to Senate with the sixth order of business, Senator Davis.
Mr. President, I ask unanimous consent. Senate advance to the ninth order of business.
Without objection, Senate advance to the ninth order of business. Messages from the House. Senate's at the ninth order of business.
March 6, 2013. Mr. President, I transmit herewith House Bill 217, 221, 224, 225, and House Bill 226, which have passed the House. Alexander, Chief Clerk.
House Bills 217, 221, 224, 225, and 226 will refer to the 11th order of business for introduction.
March 6, 2013. Mr. President, I transmit herewith Senate Bills 1031, 1101, 1102, 1103, 1104, 1001, 1003 as amended, 1004, and Senate Bill 1027, which have passed the House. Alexander, Chief Clerk.
Senate Bills 1031, 1101, 1102, 1103, 1104, 1001, 1003 as amended, 1004, and 1027 will refer to the Judiciary and Rules Committee for enrolling.
March 6, 2013. Mr. President, I transmit herewith enrolled House Concurrent Resolution 5, House Bills 137, 93, 128, 129, and House Bill 132 for the signature of the President. Alexander, Chief Clerk.
The President has signed House Concurrent Resolution number 5, House Bill 137, 93, 128, 129, 132, and they will be returned to the House.
There is no further business in the ninth order, Mr. President.
Senate will advance 10th order of business. Motions and resolutions. Senate's at the 10th order of business has for final consideration Senate Concurrent Resolution number 120. The Secretary will read the resolution.
In the Senate Concurrent Resolution number 120 by Judiciary and Rules Committee, a concurrent resolution stating findings of the legislature and commending the Boise School District for its 2013 Read-Write Award of Excellence, its continuing commitment to Read-Write program, and its focus on
Mr. President.
Senator Buckner-Webb.
I ask unanimous consent that further reading of SCR 120 be dispensed with, and the journal show that it has been read at length.
Hearing no objection, so ordered.
Mr. President, I move the adoption of SCR 120.
Senator Fulcher.
Second the motion.
Been moved and seconded. Senate adopts Senate Concurrent Resolution number 120. Senator Buckner-Webb is recognized to open debate on the resolution.
Mr. President, it's my privilege to stand before you this morning, excuse me, asking your support for SCR 120. This resolution commends the Boise Independent School District for exemplary dedication and commitment to the success of Boise students. It honors the Boise School District for receiving the 2013 Read-Write Award of Excellence. The Read-Write program embraces an innovative instructional methodology. The program is a scientific approach to helping children read with focus on complex cognitive processing essential for reading excellence. Read-Write creates an environment to enable struggling readers to make new discoveries about ways to achieve excellence. The Boise School District has done an outstanding job of implementing the program, and in doing so, the district has provided a valuable service to our community by aiding thousands of Boise students with reading challenges to find success. For nearly 15 years, the Boise Independent School District has embraced the practices essential to this program, which have enabled students to achieve those great results. Since its inception, the program has helped an estimated 2,000 children and teens with significant reading challenges. Results realized over the past decade include, on average, an 11% improvement in the number of kindergarten through third grade students reading at grade level, and kindergarten through third grade students in the district read a grade level 9 percentage points higher than the state average. Finally, the Boise School District is one of only 7 recipients of this prestigious award in the United States and one of 2 school districts. It's my honor to personally commend the Boise School District. In recognition of their 2013 Read Write Award of Excellence, as well as their outstanding success in educating the youth of Boise, I ask for your affirmative vote. Debate is open.
Further debate? Senator Durst.
Mr. President, I couldn't pass up a chance to show some pride for my local school district. Besides the senator from 19 and I both being graduates of Boise High School, and myself personally being a third-generation graduate of Boise High School with children that are currently in the Boise School District, I'm especially proud of the great work that's being done by Superintendent Coberly and others in our district, especially our teachers who do a fantastic job with the students that they have, especially in some areas where socioeconomically and ethnically there's quite a bit of diversity and challenges. And so this outcome, given those challenges, is especially noteworthy. And so I'm excited that the Boise School District is continuing to lead in education in Idaho, and I appreciate your support.
Further debate? Hearing no further debate, Senator Buckner-Webb is recognized to close debate.
Mr. President, and to the senator from 18, I thank you for your comments. Boise High rules. Debate is closed.
Debate being closed. The question is, will Senate concurrent resolution number 120 pass the Senate? All in favor say aye. All opposed, nay. The ayes have it. The Senate concurrent resolution has been adopted and will be transmitted to the House. The Senate now has for final consideration House concurrent resolution number 7. The Secretary will read the resolution.
In the House of Representatives, House concurrent resolution number 7 by Transportation and Defense Committee. A concurrent resolution stating findings of the legislature and rejecting a certain rule of the Idaho...
Mr. President.
Senator Rice.
Mr. President, I ask unanimous consent that further reading of HCR 7 be dispensed with and the journal show that it has been read at length.
Hearing no objections to order.
Mr. President, I move adoption of HCR 7.
Senator Buckner-Webb.
Mr. President, I second the motion.
Moved and seconded. The Senate adopt House concurrent resolution number 7. Senator Rice is recognized to open debate.
Mr. President, members of the Senate, this concurrent resolution rejects the rules on a driver special plate legislation that we passed last year. The department really kind of struggled with this one, and the rule they came up with wasn't workable. Ran into some problems with the rule attempting to limit the legislature on if we passed a special plate bill. And it really brought to the front that we needed to adjust what we passed last year into a process rather than preliminary requirement on things. And so this rule needs to be rejected. There will be a bill that's now on the second reading calendar to fix the statute so that we have something that will actually work and comport with the state constitution.
Further debate? Hearing no further debate, Senator Rice recognized to close debate.
Mr. President, debate is closed.
Debate being closed. The question is the House concurrent resolution number 7 passed the Senate. All in favor say aye. All opposed, nay. The ayes have it. House concurrent resolution number 7 has passed the Senate, and it will be transmitted to the House. The Senate now has for final action the report of the State Affairs Committee on the appointment of Roger Jones, the Idaho Lottery Commission. The Secretary will read the report.
March 4th, 2013. The State Affairs Committee reports it has had under consideration the gubernatorial appointment of Roger L. Jones to the Idaho Lottery Commission, term to expire January 1st, 2017. The committee recommends that said appointment be confirmed by the Senate. McKenzie, Chairman.
Senator Brackett.
Mr. President, I move the Senate adopt the committee report.
Senator Buckner-Webb.
Mr. President, I second the motion.
Moved and seconded. The Senate adopt the committee report. Senator Brackett is recognized to open debate on the committee report.
Thank you, Mr. President. Members of the Senate, Roger L. Jones of Glens Ferry has been appointed. It is my pleasure to bring his name. Been appointed to the Idaho Lottery Commission. Mr. Jones has served on the commission for 15 years. He's been appointed by 4 different governors. For the past 6 years, he's served as chairman. Mr. Jones graduated from Minidoka High School. He was an Eagle Scout and then a University of Idaho graduate, where he was member of the Sigma Alpha Epsilon fraternity. As a university alum, he has served as president of their Alumni Association and also their Vandal Boosters. He is a member of the Shriners and a 32nd degree Mason. Mr. Jones is chairman and CEO of Cormella Winery and Vineyard Greens Golf Course in Glens Ferry. He began his career at Roland Jones Potatoes Incorporated and at Magic Valley Foods, both in Rupert. Mr. Jones has served as the past chairman of the Idaho Potato Commission and president of Potato Processors of Idaho. He's also been past chairman of the United Fresh Fruit and Vegetable Association and was a member of the Secretary of Agriculture Advisory Board on the U.S.-Canadian Fair Trade Agreement. Mr. President, good senators, Mr. Jones is a long-standing leader and a well-respected member of the Idaho Lottery Commission. And Mr. President, did I mention that he is a University of Idaho graduate?
You did, Senator. Good job.
Senators, I encourage you to reappoint him to this one last term on the commission. Thank you, Mr. President. With that, debate is open.
Further debate? Hearing no further debate, Senator Brackett is recognized to close debate.
With that, Mr. President, debate is closed.
Debate being closed. The question is, will the Senate adopt the report of the State Affairs Committee on the appointment of Roger Jones to the Idaho Lottery Commission? All in favor say aye. Aye. All opposed, nay. The ayes have it. The report has been adopted. The governors will be so notified.
There is no further business in the 10th order, Mr. President.
Senator Vance, the 11th order of business, introduction, first reading of bills. Senator Davis.
Consent that all bills on first reading be read by number, author, and title only, and the journal show have been read at length.
Hearing no objection, so ordered.
In the Senate, Senate Bill number 1145 by State Affairs Committee, an act relating to workers' compensation to extend a temporary premium tax reduction and to extend certain deduction provisions. In the Senate, Senate Bill number 1146 by State Affairs Committee, an act relating to education to revise provisions relating to certain conditions concerning the declaration of a financial emergency. In the Senate, Senate Bill number 1147 by State Affairs Committee, an act relating to education to remove language relating to fact finders, appointment and hearings, to establish provisions relating to terms of agreements, to provide that agreements shall have a 1-year duration. In the Senate, Senate Bill number 1148 by State Affairs Committee, an act relating to education to revise a date and to make technical corrections, to remove language relating to notice concerning renewal of contract, to revise a date. In the Senate, Senate Bill number 1149 by State Affairs Committee, an act relating to education, to revise language relating to entering into a negotiation agreement. In the Senate, Senate Bill number 1150 by State Affairs Committee, an act relating to education, to establish provisions relating to an employee's appeal to the District Court. In the Senate, Senate Bill number 1151 by Judiciary and Rules Committee, an act relating to criminal procedure, to revise provisions when relief from felony conviction may be granted and to provide procedures.
Senate Bills 1145, 1146, 1147, 1148, 1149, 1150, and 1151 will all be referred to the Judiciary and Rules Committee for printing.
In the House of Representatives, House Bill number 217 by State Affairs Committee, an act relating to motor vehicles, to revise provisions relating to the negligent operation of a loaned vehicle. In the House of Representatives, House Bill number 221 by Education Committee, an act relating to education, to provide for an exception and to make technical corrections, to revise provisions relating to limitations on the approval of a public charter school by a Board of Trustees. In the House of Representatives, House Bill number 224 by Education Committee, an act relating to education to establish provisions governing certain contracts. In the House of Representatives, House Bill number 225 by Education Committee, an act relating to education relating to special applications of the Educational Support Program. In the House of Representatives, House Bill number 226 by Education Committee, an act relating to education to establish provisions relating to the use of full-term average daily attendance to calculate support units for certain alternative secondary schools.
House Bill 217 will be referred to the Transportation Committee. House Bills 221, 224, 225, and 226 will all be referred to the Education Committee.
There is no further business in the 11th order, Mr.
Senate
President.
advance 12th order of business, second reading bills. Senator Davis.
Mr. President, I ask unanimous consent that all bills on second reading be read by number and author only in the general show. They've been read at length.
Without objection, Senate be these. Senate will come to order. Senate is in the 12th order of business. Senator Cameron.
Mr. President, is Senate Bill 1141 in the 12th order?
It is, Senator.
Mr. President, I ask unanimous consent that Senate Bill 1141 be returned to the Finance Committee. May I explain?
You may.
Thank you, Mr. President. We have found a few errors in that budget, and we need to make some modest adjustments if we could have it back before the committee.
Hearing no objection, Senate Bill 1141 will be returned to the Finance Committee.
Mr. President.
Senator Davis.
Mr. President, I ask unanimous consent that all bills in the second reading be read by number and author only in the journal show they've been read at length.
Hearing no objection, so ordered.
In the Senate, Senate Bill number 1140 by Finance Committee. In the Senate, Senate Bill number 1142 by Finance Committee. In the Senate, Senate Bill number 1143 by Finance Committee. In the Senate, Senate Bill number 1144 by Finance Committee. In the House of Representatives, House Bill number 168 by Transportation and Defense Committee. In the House of Representatives, House Bill number 169 by Transportation and Defense Committee. In the Senate, Senate Bill number 1021 by Health and Welfare Committee. In the House of Representatives, House Bill number 139 by Revenue and Taxation Committee. In the House of Representatives, House Bill number 141 by Revenue and Taxation Committee. In the Senate, Senate Bill number 1111 by State Affairs Committee.
Senate Bills 1139, 1140, 1142, 1143, 1144, and House Bill 168, 169, Senate Bill 1021, and House Bill 139, 141, and Senate Bill 1111 will all be referred to the 13th order of business, third reading calendar.
There is no further business in the 12th order, Mr.
Senator
President.
Davis.
President, I ask unanimous consent in advance of the 14th order of business resolve itself into the Committee of the Whole and the Senator from 20, Senator Winder, be appointed to take the chair.
Hearing no objection, Senate advance 14th order of business. Senate's at the 14th order of business, and the Senate will be at ease, subject to call of the chair.
So I got you two amendments yesterday, but the bill still doesn't look like it's on 14th.
Senate Bill 1133.
Yeah.
It's because I just read it across the desk today.
Okay. How long does it normally take when we make a motion from committee to get it?
Then it goes on the calendar for the next day.
Because we did that on a Tuesday. We made the motion on Tuesday to move it to general order, so it should have gone there from yesterday.
I didn't get the report until after we got off the floor yesterday.
Okay.
So if I don't have the report, if the secretary doesn't send it out, then
okay, it's 11:33.
I just read it across the desk right now.
Just today. Okay, I thought it was.
Yeah, but we're planning on going into the 14th tomorrow.
Okay.
Yeah.
So you've got those.
And I have those. Yep.
Okay.
What are these up here?
Committee of the whole Senate will come to order. Secretary will read the list of bills before the Senate, or before the committee.
Senate Bill 1059 with one amendment. Senate Bill 1018 as amended with one amendment. Senate Bill 1118 with no amendment. House Bill 130 with one amendment. Senate Bill 1114 with no amendments. House Bill 167 with one amendment. Senate Bill 1045 with one amendment.
Committee of the whole will now have under consideration Senate Bill 1059. There being no objection, the bill will be considered read in full. There being no objection, amendment to Section 1 will be considered read in full.
Moved by Senator Mortimer, seconded by Senator Lakey, that the amendment to Section 1 be adopted.
Senator Mortimer is recognized to open debate.
Thank you, Mr. Chairman. Senators, in discussion about this bill, it was determined that we needed to add the language that you're seeing in the amendment to Section 1 to limit the liability of the state in this particular instance. In the original bill, the language being added is to adhere to the current practice in our correctional facilities, and this language that we're adding is to limit liability and further clarify. Debate is open.
Debate being open, is there debate in opposition? Hearing none, Senator Mortimer is recognized to close debate.
Thank you, Mr. Chairman. Debate is closed.
Debate being closed, the question is, shall amendment to Section 1 be adopted? All in favor signify by saying aye. Aye. Opposed, say nay. Ayes have it. Amendment to Section 1 is adopted. Committee of the whole will now have under consideration Senate Bill 1018.
Mr. Chairman. I'm sorry, Mr. Chairman. Mr. Chairman, I move the one the committee rise. It is had under consideration Senate Bill 1059, returned same as amended without recommendations.
Mr. Chairman, I second the motion.
Heard the motion. All in favor signify by saying aye. Aye. Opposed, say nay. Ayes have it. Motion is adopted. Committee of the whole will have under consideration Senate Bill 1018 as amendment. Being no objection, the bill will be considered read in full. Being no objection, amendment to Section 2 will be considered read in full.
Moved by Senator Lakey, seconded by Senator Rice, that the amendment to Section 2 be adopted.
Senator Lakey is recognized to open debate.
Thank you, Mr. Chairman. Senators, again, this bill was the proposal to update the maximum penalties for those found in contempt for failing to appear for jury duty. We were initially looking at a compromise of maximum penalty of $1,000, and hearing some additional concern and in a desire to build consensus. The Supreme Court has agreed that maximum penalty would be $500 instead of the $1,000. That's the purpose of the amendment, Mr. Chairman.
Debate being open, is there debate in opposition? Hearing none, Senator Lakey is recognized to close debate.
Thank you, Mr. Chairman. Debate is closed.
Debate being closed, the question is, shall amendment to Section 2 be adopted? All in favor signify by saying aye. Aye. Opposed, say nay. Ayes have it. Amendment to Section 2 is adopted.
Mr. Chairman.
Senator Fulcher.
Mr. Chairman, I move that when the committee rise, your report it has had under consideration Senate Bill 1018 returned same as amended without recommendation.
Mr. Chairman, I second the motion.
Heard the motion. All in favor signify by saying aye. Aye. Opposed, say nay. Ayes have it. And amendment to Section 2 is, or the motion is adopted. Committee of the Whole will now have under consideration House Bill 130. There being no objection, the bill be considered read in full. Being no objection, amendment to Section 1 will be considered read in full.
Moved by Senator Tippett, seconded by Senator Pierce, that the amendment to Section 1 be adopted.
Senator Tippett is recognized to open debate.
Thank you, Mr. Chairman. The Senator's House Bill 130 deals with the election of irrigation district directors. And currently, there's a bit of an issue in the law that says that when someone is elected but not qualified to hold office, the existing director is carried over for the full term of 3 years, up to 3 years. If it's not a vacant position, directors are required to serve until their successors are elected and qualified. So it doesn't allow for an election to replace someone who is elected and then not qualified. So the assumption is they have to serve the full term. Unless that person were to resign, then maybe they could have an election. These are amendments that are proposed by the sponsors just to clarify that, to allow that election to take place on the next general election date for the irrigation district, so you don't have to wait up to 3 years. It's a rare situation, but it has happened once in the past. I just want to make sure this doesn't happen again, so I would encourage your support. Thank you, Mr. Chairman.
Debate being open, is there debate in opposition? Hearing none, Senator Tippett is recognized to close debate on Section 1.
Thank you, Mr. Chairman. Debate is closed.
Debate being closed, the question is, shall amendment to Section 1 be adopted? All in favor signify by saying aye. Aye. Opposed, say nay. Ayes have it. Amendment to Section 1 is adopted. Now, for consideration, amendment to Section 2. There being no objection, will be considered read in full.
Moved by Senator Tippett, seconded by Senator Pierce, that the amendment to Section 2 be adopted.
Mr. Chairman.
Senator Tippett is recognized to open debate on Section 2.
Thank you, Mr. Chairman and Senators. Same issue. We just need to amend part of Section 2, and later we'll have amendments to Section 3 as well, but it's the same issue. Thank you. Debate is open.
Debate being open, is there debate in opposition? Hearing none, Senator Tippett is recognized to close debate.
Thank you. Debate is closed.
Debate being closed, the question is, shall amendment to Section 2 be adopted? All in favor signify by saying aye. Aye. Opposed, say nay. The ayes have it. Amendment to Section 2 is adopted. We'll now have under consideration amendment to Section 3. There being no objection, the amendment will be considered read in full.
Moved by Senator Tippett, seconded by Senator Pierce, that the amendment to Section 3 be adopted.
Senator Tippett is recognized to open debate.
Thank you, Mr. Chairman. Same debate. Debate is open.
Debate being open, is there debate in opposition? Hearing none, Senator Tippett is recognized to close debate.
Thank you. Debate is closed.
Debate being closed, the question is, shall amendment to Section 3 be adopted? All in favor signify by saying aye. Aye. Opposed, say nay. Ayes have it. Amendment to Section 3 is adopted. Being no objection, correction to the title be considered read in full.
Moved by Senator Tippett, seconded by Senator Pierce, that the correction to title be adopted.
You've heard the motion. All in favor signify by saying aye. Aye. Opposed, say nay. Ayes have it. Correction title is adopted.
Mr. Chairman.
Senator Fulcher.
Mr. Chairman, I move when the committee rise, it reported has had under consideration House Bill 130, returned same as amended without recommendation.
Mr. Chairman, I second the motion.
You've heard the motion. All in favor signify by saying aye. Aye. Opposed, say nay. Ayes have it, and motion carries. The Committee of the Whole will now have under consideration House Bill number 167. Being no objection, the bill will be considered read in full. Being no objection, amendment to Section 3 will be considered read in full.
Moved by Senator Hagedorn, seconded by Senator Rice, that the amendment to Section 3 be adopted.
Senator Hagedorn is recognized to open debate.
Thank
Thank you, Mr. Chairman. This is basically we're removing some information that in the bill that takes out the Attorney General's designee and slides up everything else for the board. The Attorney General felt that they might have some conflict had that language remained, so we're just removing that. Debate is open.
Debate being open, is there debate in opposition? Hearing none, Senator Hagedorn is recognized to close debate.
Thank you, Mr. Chairman. Debate is closed.
Debate being closed, the question is, shall amendment to Section 3 be adopted? All in favor signify by saying aye. Aye. Opposed say nay. Ayes have it. Amendment to Section 3 is adopted. Senator Fulcher.
Mr. Chairman, I move when the committee rise, a report it has had under consideration House Bill 167, returned same as amended without recommendation.
Mr. Chairman, I second the motion.
You've heard the motion. All in favor signify by saying aye. Aye. Opposed say nay. Ayes have it. Motion's adopted. The Committee of the Whole will now have under consideration Senate Bill 1045. There being no objection, the bill will be considered read in full. Being no objection, amendment to Section 1 will be considered read.
Moved by Senator Hagedorn, seconded by Senator Lakey, that the amendment to Section 1 be adopted.
Senator Hagedorn is recognized to open debate.
Thank you, Mr. Chairman. Lo and behold, in all of Idaho Code, there is no definition of active duty. And so what we're doing is we're adding this term for this particular section of code, the definition of active duty. With that, debate is open.
Debate being open, is there debate in opposition? Hearing none, Senator Hagedorn is recognized to close debate.
Thank you, Mr. Chairman. Debate is closed.
Debate being closed, the question is, shall amendment to Section 1 be adopted? All in favor signify by saying aye. Aye. Opposed say nay. Ayes have it. Amendment to Section 1 is adopted. Being no objection, correction of the title be considered read.
Moved by Senator Hagedorn, seconded by Senator Lakey, that the correction to title be adopted.
You've heard the motion. All in favor signify by saying aye. Aye. Opposed say nay. Ayes have it. Correction title is adopted.
Mr. Chairman, I move when the committee rise, a report it has had under consideration Senate Bill 1045, returned same as amended without recommendation.
Mr. Chairman, I second the motion.
You've heard the motion. All in favor signify by saying aye. Aye. Opposed say nay. Motion is adopted.
Mr. Chairman, I move that the committee rise and report.
Mr. Chairman, I second the motion.
You've heard the motion. All in favor signify by saying aye. Aye. Opposed say nay. Ayes have it. Motion carries. The Committee of the Whole Senate is dissolved.
Getting that away from me.
Me too.
Yeah, I know. He likes to whack that one because it makes you jump. You did a pretty good job today when we started. So I was just saying she took away your big rubber mallet. That's because I scared her. She's hiding it under her desk. I'll give her a ready for now.
Ready? So we'll come to order. Prior to going to East, the Senate was at the 14th order of business. Senator Bach will be recognized at this order of business. Senator Winder.
Thank you, Mr. President. Mr. President, we, your Committee of the Whole Senate, beg leave to report we've had under consideration Senate Bill 1059, Senate Bill 1018 as amended, House Bill 130, House Bill 167, Senate Bill 1045, and returned same as amended without recommendation. We further report we've had under consideration Senate Bill 1118 and Senate Bill 1114, report progress, and beg leave to sit again. Mr. President, I move adoption of the committee report.
Senator Butner-Webb.
Mr. President, I second the motion.
Moved and seconded that the Senate adopt the committee report. All in favor say aye. Aye. All opposed nay. The ayes have it. The report has been adopted. Senate Bills 1059, 1018 is amended, and 1045 will be referred to the Judiciary and Rules Committee for engrossing. Amendments thereto will be referred to the Judiciary and Rules Committee for printing. House Bills 130 and 167 will be filed for first reading as amended, and the amendments thereto will be referred to the Judiciary and Rules Committee for printing. Following measures will hold their place On the 14th order of business, Senate Bill 1118 and Senate Bill 1114.
There is no further business in the 14th order, Mr. President.
Senator Davis.
Mr. President, I ask unanimous consent, Senate return to the 13th order of business.
Without objection, Senate return to the 13th order of business, third reading of bill. Senate's at the 13th order of business and has for final consideration Senate Bill 1029. The Secretary will read the bill.
In the Senate, Senate Bill number 1029 by State Affairs Committee, an act relating to codifiers corrections, to make codifiers corrections and to make technical corrections.
Mr. President.
Senator McKenzie.
Thank you, Mr. President. I ask unanimous consent we dispense with further reading of Senate Bill 1029 by our Journal Show that we read it the third time at length, section by section, and it's now before the Senate for final consideration.
No objection. Senator McKenzie is recognized to open debate.
Thank you, Senators. This is one of my favorite bills. According to my notes, I've carried this in 2005, 2006, 2007, 2008, 2009, and 2011. This is a good government bill. We are actually cleaning up code. For those who are new to the body, this is a bill that we run every year, actually Legislative Services drafts. It corrects items in the code either because we've made multiple amendments to the same areas of code and the numbering's off, or we correct titles. Or things like that. This year, if you look through it, it mostly relates to titles. Legislative Service has now gone to the protocol of not capitalizing proper names anymore, and so you'll see out through there different titles are now in lower cases. We changed veterans benefits, veterans benefits, singular to veterans, because we have more than one veteran in the state. We changed junior college to community college, and those are actually the most substantive changes that get made in this bill, even though it's got 17 different sections. Mr. President, I'd be happy to stand for questions, but debate's open.
The debate, Senate Bill 1029. Hearing no further debate, Senator McKenzie is recognized to close debate.
Debate is closed.
Debate being closed. Question is, the Senate Bill 1029 pass. The Senate Secretary will call the roll.
Baer. Bach. Brackett.
Aye.
Buckner-Webb. Cameron. Davis. Durst. Fulcher. Getty. Guthrie. Hagedorn. Hyder. Hill. Johnson. Keogh. Lacey. Lakey. Lodge. Martin. McKenzie. Mortimer. Nonini. Nuxel. Patrick. Pierce. Rice. Schmidt. Sidaway. Stennett. Thane. Tippett. Vick. Work. Winder. Baer. Bach.
Roll call shows 35 ayes, no nays, no absence, excused, majority haven't voted in the affirmative. Senate Bill 1029 is passed Senate. The correction title hearing and the title is approved. Senate Bill 1029 will be transmitted to the House and now is for final consideration. Senate Bill 1078, Secretary will read the bill.
In the Senate, Senate Bill number 1078 by State Affairs Committee, an act relating to public post-secondary educational institutions, to provide that no state post-secondary educational institution shall take any action or enforce any policy that would deny a religious student group any benefit available to any other student group.
Mr. President.
Senator McKenzie.
Thank you, Mr. President. I ask unanimous consent that we dispense with further reading of Senate Bill 1078. But our journals show that we read it at length and that it is now before the Senate for final consideration.
Hearing no objections, Senator McKenzie is recognized to open debate.
Thank you. Thank you, Mr. President. Senators, this one is a little more substantive than the last one. What this addresses is a proposed change in policy at one of our public universities that would exclude from campus any student group that required leaders of the student group to agree with the group's religious beliefs. The ones that it specifically has applied to was a group called Campus Crusade and InterVarsity, but it would apply to basically any religious-based student group that required leaders to agree with the religious beliefs of that group. If you've got the proposed law before you, Senate Bill 1078, it basically would disallow the denial of benefits to those student groups based on a requirement that leaders adhere to sincerely held religious beliefs or standards of conduct. Benefits in this conduct are basically those available to student groups on campus. It's recognition as a student group, registration, access to use rooms on campus, the use of channels of communication, which is the bulletin boards, and then funding sources otherwise available to any other student group through the state's post-secondary education institution. So if student groups can apply for student funds for activities, pizza, or whatever, they wouldn't be excluded from that. And just a little background on how this got before us. I had participated in a conference this summer, an institution called the Ethics and Public Policy Center and their American Religious Freedom Program. The senator from 33, a member from the body across the way, and I went back, and it was kind of a ecumenical organization promoting religious liberty of different religions in multiple different areas, not specifically related to student groups, and that actually wasn't something that came up. As a result of that, Idaho was one of the states that formed a religious liberty caucus just to as kind of a clearinghouse for ideas to track these issues as they come up in different states. There's different senators and members of the body across the way who are members of that. From that, I was contacted by individual attorney who represents the Christian Legal Society, who indicated that one of the universities in Idaho was changing its policy to exclude campus groups because they had that requirement for their leadership. And it was a proposal that would go into effect basically July 1st of this year, unless it otherwise went into place. And so they suggested language. We'd vetted that language with different organizations that litigate in this area, as well as with our Attorney General. And I'd sent you the letter from the Attorney General related to that, so you could see that, so that just to see it complies with both the Constitution, case law, as well as Idaho's Constitution. We have a provision in our Constitution that a lot of state constitutions from around that time had developed. They're called Blaine Amendments. What they basically provide is that the state doesn't promote any religion, and so states that have those, there's called Blaine Amendments, and we verified that if we make this change, it doesn't run afoul of that, and that this is actually a way to promote a voice on campus and promote speech on our campuses. And just to give you a context, other states have used this or similar language. Virginia's governor just signed into law very similar language. The difference that theirs applies both to leadership and to members. If we pass this, it doesn't apply to membership, so that any person who wanted to could be a member of that organization. Ohio had passed something similar June of 2011. Arizona passed theirs in the spring. Texas has a what I'd probably call a heavy-handed version of this that they passed. South Carolina asked for a copy of our language from the chairman of their Judiciary Committee, and he introduced that February 28th. And so it's something we're seeing in other states, but it really comes down to protecting a voice on campus to participate in the debate. Groups that are religiously based should have access to our campuses just like other groups. I think It's a vital form of the debate that goes on campuses, and we should do what we can to protect that voice and keep it part of the debate there, as it has been since really we had our public universities in the state. And I'd just like to thank those who'd worked on this with me, and with that, Mr. President, debate is open.
Debate being open. Is there further debate? Senator Baer.
Mr. President, would the good senator from 13 yield to a question?
Yes.
Senator McKenzie. Senator Baer.
Is it to be understood, Mr. President, that this applies to all religions, regardless of where they originate?
Senator McKenzie.
Mr. President, and Senator from 31, it wouldn't discriminate between religions.
Okay. Would the good senator yield again?
Senator McKenzie.
Would.
Senator Baer.
So, good senator, if a radical Middle East religion, and I hope I don't wade into a trouble here, but not my intention, wants to start a group on a campus who are known to be active terrorists or something like that, would then that university have the right and be able to prevent that terrorist organization in the name of their religion from opening and starting a religious group on that campus?
Senator McKenzie.
Thank you, Mr. President. And Senator from 31, that's a good question that I had asked as well. It doesn't change the status of those. The protected speech that an organization would have isn't changed, so that if there's an organization that advocates violence, things like that, they still would be prohibited, just as they would beforehand. But your question goes to a free speech issue that the Supreme Court's addressed, but basically organizations that advocate violence, free speech doesn't protect that. So organizations that, like in your example, wouldn't be allowed on campus just like they wouldn't be right now.
Okay, thank you.
Further debate? Hearing no further debate, Senator McKenzie. Senator Stennett.
You're awfully fast, Mr. President. Thank you, Mr. President. Debate the bill.
You have the floor.
Thank you, Mr. President. Good senators. We had a lot of discussion amongst ourselves about this, and I think that, first of all, I want to make sure that everyone understands that I think most of us, and myself in particular, who I can speak for, embrace the practice of open student clubs of all varieties at our university campuses. And I'm also pleased to see that all religious groups, Christianity, Judaism, Islam, can be represented in this bill because it does not specify any particular group. But we have to understand that the practice right now, the members already elect the leaders who best represents them. It would be counterintuitive that any group would take somebody who walks in who does not think at all like-minded and then make him a leader within their group. It just doesn't make any sense. And so this is supposed to be preserving something that's already regular practice. And with this all-comers policy with most of our universities, the current policy accomplishes this with respect to promoting discussion on every range of viewpoints in a collection of student forums that themselves are unbiased, while still recognizing free speech and the expression of rights that all citizens have. This is something that students coming into universities are very impressionable. They want to understand things also beyond what's in the classroom, and we all know that any of us who've gone through education on campuses, a lot of what's outside the classroom taught us as much as what was inside the classroom, and having that ability to be able to be open to all venues. My hesitation with this bill, however, is that by naming religious groups specifically, we've carved out a special benefit for a select group. And it gives a different status to religious groups than it does to all the other hundreds of groups on a campus. And I think that that's a bit disturbing. I understand what the intent is. Really, already they are electing their leaders that represent them best. And by virtue of taking a select group out of this to the exclusion of other student groups, I think is misguided. Thank you, Mr. President.
For the debate, Senator Bach.
Yes, thank you, Mr. President, fellow senators. I have really mixed feelings about this bill for a number of reasons. First of all, it may sound like a bit of a platitude, but we have the rights that we have, and those are granted by the Constitution. And any group exercising its religion and freedom of speech, freedom of association rights on a college campus can do that. This bill doesn't change that. And in that sense, it's unnecessary because it's only acknowledging that particular group as a group entitled to receive the benefits that every other group is entitled to receive. So I question the need, but it goes deeper than that because the First Amendment says the state can neither advance nor hinder religion. And that is a fundamental pillar of the foundation of this country. It is the reason why Catholics, pilgrims, you name them, you name the group, came to this country several hundred years ago. It is the reason why we have free exercise of religion in an enormous diversity in this country. And so the fact that, or the possibility that state monies can go to religious group for religious activities is quite simply unconstitutional. You can't do it. To the extent that that would occur, this is inviting litigation. It is inviting involvement in religious activities that our founding fathers and mothers had been so concerned about several hundred years ago. This wades in a way that makes me feel really uncomfortable. And I will say that as someone who has grown up in a Lutheran church, who is a member of the Catholic Church, who has long held deeply religious values, spiritual values. We have to be careful when we go in this direction because, like the good senator has said, there is apt to be participation of groups that maybe we don't feel comfortable about sometimes. And if you're willing to accept this kind of participation or involvement with groups that may have a Christian heritage or a Buddhist heritage, you also have to accept it for all other groups. And that's what makes this little incursion into the activities on campus is so dangerous. And this kind of meddlesome activity, I think, is something that we should reject, and I intend to vote against it. Thank you.
For the debate, Senator Rice.
Mr. President, members of the Senate, it's kind of an interesting little bill. Apparently, we have one of our public universities that intends to discriminate against religion, not treat religion equally with secular groups. This bill does not give religious groups an advantage. It merely prohibits giving them a disadvantage merely on the basis that they are a religious group. Our founding fathers would have been appalled that we even had to have this kind of a discussion. Now, as to groups with terrorist leanings, whether they were secular groups or religious groups, they both be barred. We can do that because we're treating them the same. The the fact is this is a good bill. It's an appropriate bill. It actually avoids litigation. I would point out that if one of our universities were to follow through with a policy discriminating against religion, that would lead to litigation. This bill prevents the need for litigation over the fact that you can't discriminate against religion, just like you can't discriminate in favor of religion as a public body. That's what it does. And this is a good bill, and I support it.
Further debate? Hearing no further debate, Senator McKenzie is recognized to close debate.
Great. Thank you, Mr. President. Appreciate the debate. It is a real issue. It's a live issue. One of our universities is changing its policy to exclude university organizations, and so I think it's timely, and I think it's a policy that we should address and set. Thank you, Mr. President. With that, debate's closed.
Debate being closed. The question is, Senate Bill 1078 pass. Senate Secretary call the roll.
Bear, Bayer, Bach, Brackett, Buckner-Webb, Cameron, Davis, Durst.
Senator Durst.
Mr. President, may I explain my vote?
60 seconds.
Thank you, Mr. President. I'll take 60 seconds, and I'll try to talk slowly at the same time. Campus Crusade First Christ, InterVarsity Christian Fellowship of Christian Athletes. I was actually a leader, college leader for FCA for a period of time, and I can tell you that this is a problem. And despite what we're saying about elections and how these people have already been supported by their peers, the reality is that some of these national organizations require leadership to sign oaths to say that they do support it. And so what we're trying to do here is prevent those national organizations that require those oaths to be signed to being discriminated against. And I think this is a great bill. I vote aye.
Senator Durst to be recorded as voting aye.
Fulcher, Getty, Guthrie, Hagedorn, Hyder, Hill, Johnson, Keogh, Lacey, Lakey, Lodge, Martin, McKenzie, Mortimer, Nonini, Nuxel, Patrick, Pierce, Rice, Schmidt, Sidaway, Stennett, Thane, Tippett, Vick, Work, Winder, Buckner-Webb, Davis.
Senator Davis.
I explain my vote.
60 seconds.
Thanks, Mr. President. Senators, the First Amendment to our Constitution, the first freedom referenced in there is the free exercise of religion. And if there is no problem, then there shouldn't be a problem memorializing the absence of the problem. And this provides the certainty. The U.S. Supreme Court in the early 1990s changed the compelling governmental purpose to the more rational relationship standard when it comes to the free exercise of religion, and that troubles me. Anytime we have an opportunity to shore up and protect those rights, that's something that I want to do. And as a result of that, I'll be voting aye, and I vote aye.
Senator Davis will be recorded as voting aye.
Johnson, Work.
Senator Work, 60 seconds.
Thank you, Mr. President. I agree completely with everything that the senator from 33 just said. Protection of religion is really important. Here we're talking, though, about the ability of a select group of student organizations to require an oath that be signed by leaders. We're not treating everybody equally here. What we're trying to do is create an unequal playing field. Because of that, I just can't support this, and I'll be voting no.
Senator Work will be recorded as voting no. Roll call shows 30 ayes, 5 nays, no absent, excused, majority haven't voted in the affirmative. Senate Bill 1078 is passed the Senate. The correction title, hearing none, title is approved. And Senate Bill 1078 will be transmitted to the House and now is for final consideration. Senate Bill 1119, Secretary will read the bill.
In the Senate, Senate Bill number 1119 by Judiciary and Rules Committee, an act relating to mandatory income withholding for child support, to provide that income withholding orders use a certain form, and to provide that income withholding payments by employers be remitted to the
Mr. President, I ask unanimous consent that further reading of Senate Bill 1119 be dispensed with, and the Journal show it has been read the third time at length, section by section, and placed before the Senate for final consideration.
Hearing no objection, Senator Bach is recognized to open debate.
Thank you, Mr. President, fellow senators. I was promised by one of our colleagues that we would not get to my bill, but here we are. Anyway, fortunately, this is a simple one, and even though sometimes I'm slow on the uptake, sometimes I've managed to catch up to you all and would seek your support for this bill. Essentially, what this bill does is do or create in statute what the state is required to do anyway, which is to use a form approved for withholding child support in certain cases. And admittedly, I know the reaction for some is, oh, gee, another federal requirement. But the fact is that we want our children to be treated the same as any other child in any other state. We want to make sure this process for the spouses who are receiving child support, or ex-spouses who are receiving child support, are not met with a lot of hurdles or obstacles in doing that. This simply helps to make sure that we're compliant with federal requirements, and for that reason, I urge you to vote for Senate Bill 1119.
Debate being open. The question is, so Senate Bill 1119. Oh, further debate. Hearing no further debate, Senator Bach is recognized to close debate.
Yes, I was afraid of a question or two. Debate on Senate Bill 1119 is closed.
Debate being closed. The question is, so Senate Bill 1119 passed Senate. Senator Winder.
Thank you, Mr. President. I ask unanimous consent the roll call vote used for the passage of Senate Bill 1029 be now used for the passage of Senate Bill 1119.
Hearing no objection, roll call shows 35 ayes, no nays, no absence, excused, majority haven't voted affirmative. Senate Bill 1119 is passed the Senate. Are there corrections to the title? Hearing none, the title is approved. Senate Bill 1119 will be transmitted to the House. Senate now is for final consideration. Senate Bill 1122, Secretary will read the bill.
In the Senate, Senate Bill number 1122 by Judiciary and Rules Committee, an act relating to child custody, to provide a procedure for the court in the event of petition for...
Senator Lakey.
Mr. President, I ask unanimous consent that further reading of Senate Bill 1122 be dispensed with, and the Journal show it has been read a third time at length, section by section, and placed before the Senate for final consideration.
Hearing no objection, Senator Lakey is recognized to open debate.
Thank you, Mr. President and Senators. You know, I'm no country lawyer, but I aspire to that kind of homespun wisdom. I'm just a suburban lawyer, and periodically I am an Army lawyer. And in that capacity, I speak for this bill today. Often as an Army lawyer, I hear from divorced and single-parent soldiers that are concerned that their ex-spouse or the other parent of their child may be bringing some type of child custody modification while they are deployed. The Service Member Civil Relief Act, the federal law, provides some protections against that, but primarily it's in the form of a stay or protections from a default judgment without an attorney being appointed to them. But even under the Service Member Civil Relief Act, the court may enter a final order regarding child custody while that soldier is deployed. This causes a lot of stress and concern with those deployed soldiers that are serving in harm's way, and they don't need that kind of additional stress while they are serving. This bill provides that the court, after complying with the Service Member Civil Relief Act, may enter an order regarding child custody, but that child custody order is temporary. And upon that soldier's return and giving notice to the court and the other parties, that temporary order would expire within 60 days. and the original order would be back in place. However, the other party may ask the court for a hearing regarding child custody, and the court may expedite that hearing, and that temporary order would remain in place pending that request and that decision. This bill also provides for a means for soldiers to participate in proceedings electronically if it doesn't prejudice their ability to do so. But essentially, Senators, this bill allows the court to address child custody and the best interests of the child, but gives deployed soldiers some peace of mind that those orders will simply be temporary until they return, when they can participate fully in those proceedings. With that, Mr. President, debate is open.
Maybe no further debate on Senate Bill 1122. Senator Durst.
Mr. Chairman, Mr. President, would the senator from 12 yield to a question?
Senator Leahy, would you yield?
Certainly, Mr. President.
Thank you, Mr. President. Senator, sorry to ask this question, but I'm trying to make sure I understand how this works. Clearly, if a soldier is deployed, are they permitted to serve? I understand that we're saying that the parent that isn't on deployment, we're asking them not to be able to make a modification. Would the deployed soldier be able to make a modification while they're deployed if they choose to initiate the action?
Senator Leahy.
Mr. President and Senator from 18, I saw two issues in that question. First, it doesn't prohibit the other parent from requesting a modification. It simply provides that if they do make such a request and the court complies with the Service Members Civil Relief Act, an order entered would simply be temporary until they return. I suppose a soldier would be able to request a modification while they are deployed, the problem being their ability to materially participate in that would be limited.
Mr. President, would the senator yield further?
Senator Leahy?
Certainly.
Senator Durst.
Thank you, Mr. President. Just a separate question relating to child support. Typically, child support and child custody, while their proceedings are done simultaneously, are actually separate judicial actions. I'm wondering if you could tell me whether or not child support orders would be potentially changed during deployment, or if this does not cover that particular section of the child court, so the child proceedings.
Senator Leahy.
Mr. President and Senator from 18, I should have maybe also qualified I'm not much of a family lawyer in my private practice, but I believe, well, first of all, this bill does not address child support. The child support question is simply it's a question of income and level of custody. While these soldiers are deployed, they do have the ability to delegate their custodial rights to a grandparent or someone else that would keep that in place. Again, I think if there's a modification of the custody, that could impact child support. The soldier would have to address that when they return.
Thank you, Mr. President.
For the debate, Senator Rice.
Mr. President, members of the Senate, I wasn't going to get up on this one, but I thought I might. I do a lot of child custody and child support, including both representing service members and former spouses of service members. The only weakness I really see in this is that it doesn't bounce it back to the previous custody order immediately and then do a modification. You go in for temporary orders when the service member returns from a deployment. One of the challenges with the current state of the law is that, as was mentioned by the senator from 12, a service member can delegate their rights to a family member, a relative, but that may not work well with the existing schedule, and it may require some adjustments to make it work well for the child while still making sure that usually it's grandparents, it's the parents of the service member, still has a lot of meaningful contact. That helps keep the bonds that child has, but this adds to what judges can do to make sure that while a service member is deployed, that things are taken care of in a very appropriate manner that does work for the best interest of the children while still protecting the rights of the service member. Modifications of child support, I think, would generally be considered not to be appropriate during the deployment, even with this change, even though ordinarily you would modify it with the change in custody schedule. And one of the reasons for that is that this provides that order during the deployment is a temporary order. And so it's not the kind of change in circumstances that generally leads to a modification on the child support. So thank you.
Further debate? Hearing no further debate, Senator Lakey is recognized to close debate.
Thank you, Mr. President. Debate is closed.
Debate being closed. Question is, so Senate Bill 1122 pass the Senate. The Secretary, Senator Winder.
Thank you, Mr. President. I'd ask unanimous consent the roll call vote used for the passage of Senate Bill 1029 be now used for the passage of Senate Bill 1122.
Hearing no objection, roll call shows 35 ayes, no nays, no absent excused. Majority haven't voted in the affirmative. Senate Bill 1122 passed Senate. Other corrections title. Hearing none, the title is approved. Senate Bill 1122 will be transmitted to the House. Senate now is for final consideration. Senate Bill 1116 is amended. The Secretary will read the bill.
In the Senate, Senate Bill number 1116 as amended by Judiciary and Rules Committee, an act relating to organ donor notification.
Mr. President.
Senator Hyder.
Mr. President, I ask unanimous consent that further reading of Senate Bill 1116 as amended be dispensed with, and the journals show that it has been read the third time at length, section by section, and placed before the Senate for final consideration.
Hearing no objection, Senator Hyder is recognized to open debate.
Thank you, Mr. President. Good senators. Most of us carry a little card like this in our wallet. In this case, it's my driver's license, has my height and weight, residence. But on mine, in the lower corner, is the word in red, donor. It means that I've agreed to be a donor of organs at my passing. Now, that could happen on the front steps of the Capitol as I'm tripping down. That could happen in an automobile accident. It could happen in a boating accident. It could happen in a hospital. It could happen in a fire. It could happen any number of ways. But the most important thing is that when an emergency medical technician or a policeman or a fireman or someone in a hospital recognizes that I'm a donor and I am deceased, that my organs in a timely manner are transferred to a tissue bank, an eye bank, or an Intermountain Donor Services by protocol, so that those organs or eyes or tissues can be transplanted in someone that needs them. And this happens regularly on a daily basis. The purpose of 1116 as amended is to state the protocol that emergency responders are to communicate with the Idaho Communications Center as soon as possible and make that arrangement. The Communications Center has a protocol as well. They'll notify next of kin. They'll notify the organ donation services to come retrieve those organs or eyes or tissues so that might be done in an expeditious manner. Time really is of the essence here, and that's the reason for this legislation, is so that a body doesn't remain too long without those organs or tissues being harvested. There is no civil or criminal penalty if someone fails to comply or if the circumstances go beyond that time frame that where those organs can be retrieved and transplanted. So there is no penalty here if that doesn't happen, but it is an explanation of how we think it should happen in a timely manner. And with that, Mr. President, the debate is open.
For the debate. Hearing no further debate, Senator Hyder is recognized to close debate.
Thank you, Mr. President. Good senators, the debate is closed.
Debate being closed. Question is, so Senate Bill 1116 is amended past Senate. Senator Winder.
Thank you, Mr. President. I'd ask unanimous consent the roll call vote used for the passage of Senate Bill 1029 be now used for the passage of Senate Bill 1116 as amended.
Hearing no objection, roll call shows 35 ayes, no nays, no absence, excused. Majority haven't voted in the affirmative. Senate Bill 1116 is amended as passed Senate. The correction title, hearing none. Title is approved. Senate Bill 1116 is amended. Will be transmitted to the House. Senate now is for final consideration. Senate Bill 1068 is amended. The Secretary will read the bill.
In the Senate, Senate Bill number 1068 as amended by Commerce and Human Resources Committee, an act relating to members of the armed services and their spouses to allow for licensure, certification.
Senator Durst.
Mr. President, I'd ask unanimous consent that the further reading of Senate Bill 1068 as amended be dispensed with. The journal show that had been read at length, section by section, is now properly before the Senate for final consideration.
Hearing no objection, Senator Durst recognized open debate.
Thank you, Mr. President. Hopefully a brief explanation as to what this legislation does, and if there's questions, I'd be happy to answer them. Essentially, what this legislation does is provides those agencies in the state of Idaho that offer occupational licenses, whether it be cosmetology, the Board of Medicine, and everything in between, the option to be able to expedite the process in which they provide occupational licenses to service personnel and their spouses. So why are we having this discussion today? The Department of Defense has had issues when having service members deployed from one part of the country to another. So, for example, if someone was rebased from McCord Air Force Base in Tacoma to Mountain Home Air Force Base or to Gowan Field here in Idaho, those service personnel bring with them their families. And in many cases, their families, their spouses have professional occupations that they perform in addition to the services that the service member provides as well. And so this really, when those spouses come to Idaho or wherever they're being deployed to and can't begin back to work, it just prolongs the time that we have to get back to some sense of normalcy. That's already a stressful time on families. As we all know, moving can be very stressful. It's especially difficult for these service personnel. And so this just gives the occupational licensing boards the option to expedite that process. I should point out, it doesn't mandate that they do it. This section was written in accordance with the Bureau of Occupational Licenses. They provided quite a bit of feedback and input to make sure that it would meet their standards, and it does. And so I think this is a good idea to help our service personnel, and I'd encourage your support. The debate is open.
For the debate, Senator Hagedorn.
Thank you, Mr. President. Having moved 21 times in my 20-year career, there's a lot of roadblocks to overcome with family in all of those movements, and things that a family has to worry about. This removes one of those roadblocks and obstacles. This is a very good bill. Takes the burden off of spouses and family members when they move from one duty station to another. So I would appreciate your support on this. Thank you.
For the debate. Hearing no further debate, Senator Durst recognized closed debate.
Thank you, Mr. President. The debate is closed.
Debate being closed. Question is, so Senate Bill 1068 is amended past the Senate. Secretary will call the roll.
Bayer, Bach, Brackett, Buckner-Webb, Cameron, Davis, Durst, Fulcher, Getty, Guthrie, Hagedorn, Hyder, Hill, Johnson, Keogh, Lacey, Lakey, Lodge, Martin, McKenzie, Mortimer, Nonini, Nuxel, Patrick, Pierce, Rice, Schmidt, Sidaway, Stennett, Thane, Tippett, Fick, Work.
Mr. President.
Senator Work.
60 seconds to explain my vote.
Seconds.
Thank you, Mr. President. I'm not big on preferential treatments, but in this instance, when we have active military personnel that are being shuttled all around the country, the idea of being able to get their families settled in quicker, I think it's a good idea, and I'll be voting aye.
Senator Work will be recorded as voting aye.
Winder, Bach, Cameron, Lacey, McKenzie, Nonini, Nuxel, Pierce,
Roll call shows 34 ayes, no nays, 1 absent, excused, majority having voted in the affirmative. Senate Bill 1068 is amended, is passed. Senate, the correction title, hearing none, the title is approved. Senate Bill 1068 is amended, will be transmitted to the House. Senate House for final consideration. Senate Bill 1082 is amended. The Secretary will read the bill.
In the Senate, Senate Bill number 1082, as amended by Transportation Committee, an act relating to special motor vehicle license plates to establish the Idaho Volunteer Emergency Medical Service License Plate Program.
Mr. President.
Senator Nuxall.
I ask unanimous consent that further reading of Senate Bill 1082 be dispensed with and that the journal show has been read the third time at length, section by section, and placed before the Senate for final consideration.
Hearing no objections, Senator Nuxall is recognized to open debate.
Good senators, the Idaho EMS is on a cliff the same as the fiscal budget. The average age of volunteer EMS providers and the number of volunteers continue to put volunteer units in jeopardy. This bill proposes that a special plate with the words volunteer EMS provider be made available as part of a recruitment retention project. Volunteer EMS thought that recognition of time and personal cost should be recognized and rewarded. Our legislature asked that a study be made last year on volunteer EMS through town hall meetings. This study showed that volunteers comprise 53% of Idaho EMS providers. The number of volunteers of Idaho EMS has declined, though, from 2,688 in 2002 to 2,135 in 2012. Many communities, including small towns in our districts, have 2 ambulances each. The annual cost for paid EMS providers would be over $300,000 per ambulance. Providing 3 EMTs for 24/7 ambulance coverage equates to 26,280 hours of call annually. The county is required to provide EMS to the citizens, so in Idaho alone, the cost would be over $1,500,000 to staff just one paid ambulance in the current communities. This does not even factor in any of the quick response units. To staff the current Idaho ambulances that rely on volunteers with paid personnel would cost Idaho taxpayers over $72,900,000 annually. The cost to become a volunteer EMS, not including travel and time, includes a background check of $60, testing fee of $70, books costing approximately $100, and over 150 hours of additional training. Once they become a volunteer EMT, they need to commit more time to continuing education training to keep their license. And remember, again, this is just a volunteer. So we are hoping for a proactive approach to support this essential and required community service, or the service will be dropped, and the county commissioners will have to increase taxes and create ambulance taxing districts to address this vital service. This plate is only available to volunteer or compensated volunteer where less than 10% of their annual income is from EMS. EMS personnel could pay extra for the original plate, but then there would be an additional cost annually, but there should not be an additional cost annually over the standard plate or the program could fail. So Mr. Wayne Denny, the EMS director, worked out details with the Idaho Transportation Department as far as costs and proof of eligibility to keep the costs as low as possible. So in addition to the regular registration fee, the volunteer would be charged $13 for the initial issuance of plates, which would be kept to pay for the license plate program. Then there would be the regular renewal each year. Now, according to Amy at the Idaho Transportation Department, this special plate program is unique as it is not written to generate revenue for an outside entity. It is written as recognition of those that are certified EMS volunteer. This program requires the written certification of the individual applying to show proof that he is a certified EMS volunteer, both at the time of initial issuance and renewals. Then there's only the one additional fee to the individual. And the initial $13 again goes to offset the cost for the program. There are other plate programs that exist that have special eligibility requirements for the registrant, such as year of manufacture plates, classic car plates, National Guard plates. where the department has to validate information from the registrant at regular intervals. Many plate programs have their unique quirks, and this plate is simply for recognition of Idaho EMS volunteers and not intended to raise revenue for any entities. The debate is open.
The debate. Hearing no for Senator Hill.
Mr. President, would the senator from 7
Senator Nuxall, would you yield to an inquiry?
Yes, I would.
Senator Hill for the inquiry.
Thank you, Mr. President. Senator from 7. Are there any other specialty license plates that are set up this way where you don't have an ongoing fee, where it's not to be a fundraiser for that except for the initial fee? Are there others that are set up that way at all?
No, sorry, Mr. President and Senator from 34. No, this is this, according to what I understand from Amy, who has been very cooperative and worked this out with the director of EMS. No, this is unique, just showing the recognition for the volunteer EMS, that they don't charge extra to make money for. But the $13 does pay the initial license plate, pays for the issuance of the initial license plate.
Mr. President, would the senator yield further?
Senator Nuxall.
Yes, I would,
Senator
Mr.
Hill.
President.
Thank you, Mr. President. Senator from 7. So what about the renewal of the license plate when they have to have a new plate, every 5 years or whatever? Will there be the additional $30 charge at that time? And will part of that, as an initial registration, will part of that go to pay for the cost of the plate, and part of it go to the organization here, or how will that happen in the future?
Senator Nuxall.
Mr. President and good Senator from 34, my understanding is that this is like a 7-year program, but they can reuse the plates each year. They renew their regular charge, but they wouldn't be charged any more than what a normal registration fee is after the first year, because the plate program will already be made.
Okay. Thank you, Mr. President.
For the debate. Senator Work.
Mr. President, fellow senators, I appreciate EMS personnel very much. My wife actually was assigned to an ambulance before she went to medical school. And I just wanted to say I'm going to continue my lonely vigil in voting against any and all specialty license plates.
For the debate. Hearing no further debate, Senator Nuxall is recognized. Closed debate.
The debate is closed.
The debate being closed, question is, Senate Bill 1082 is amended. By the Senate Secretary will call the roll.
Baer, Bach.
Mr. President.
Senator Bach.
Mr. President, could I, not having debated, could I have 60 seconds to explain my vote?
You have 60 seconds, Senator.
Thank you, Mr. President. I want to carry on the long tradition of Senators Hammond, I think Stegner, and others to just say no to specialty plates. Somehow we've got to stop the avalanche. So I urge you to vote against this. And I do like EMS providers too.
And Senator Bach will be recorded as voting no?
That is correct. I vote no.
Brackett. Buckner-Webb. Cameron. Davis. Durst. Fulcher. Getty. Guthrie. Hagedorn. Hyder. Hill.
Mr. President, explain my vote.
60 seconds.
Again, I think this is, I appreciate these people very much too. There are many, many worthy organizations out there that I do appreciate their services. I've had a problem with specialty plates as well, but not only that, this is a specialty plate. It's being treated different than any others, and we're starting whole another program, and consequently, the senator votes nay.
Senator Hill will be recorded as voting no.
Johnson.
President.
60 seconds.
Thank you, Mr. President. I, too, have some financial concerns about the future of this plate, and so for that reason, I'm going to vote no. Thank you, Mr.
Senator
President.
Johnson will be recorded as voting no.
Keogh. Lacey. Blakey. Lodge. Martin. McKenzie. Mortimer. Nonini. Nuxall. Patrick. Pierce. Rice. Schmidt. Sidaway? Stennett? Thane? Tippett? Fick? Work? Winder? Cameron? Davis? Guthrie?
Senator Guthrie.
Lodge?
60 seconds.
Thank you, Mr. Chairman, Mr. President. Good senators, I worked several years trying to bring some sensibility to some of our EMS situations across the state. We do have a report that things might be looking a little better, but the special license plates funded through the state where it's a fundraiser for someone else just can't continue, so therefore I will vote no.
Senator Lodge will be recorded as voting no.
McKenzie? Rice? Schmidt? Winder?
Mr. President, change my vote to no.
Senator Bear will be recorded as voting no. Winder. Senator Brackett, how are you recorded on this vote?
Voted yes.
Senator Brackett will be recorded as voting aye. Is recorded as voting aye. Roll call shows 15 ayes, 20 nays. The majority having failed to vote in the affirmative. Senate Bill 1082 as amended will be filed in the office of the Secretary. The Senate now has for final consideration Senate Bill 1107 as amended. The Secretary will read the bill.
In the Senate, Senate Bill number 1107 as amended by State Affairs Committee, an act relating to revenue and taxation, to establish provisions relating to providing certain assessment notices electronically to the taxpayer.
Mr. President.
Senator Winder.
Thank you, Mr. President. I ask unanimous consent that further reading of Senate Bill 1107 as amended be dispensed with. The journal show it's been read at length the third time, section by section, and placed before the Senate for final consideration.
Hearing no objection, Senator Winder is recognized to open debate.
Thank you, Mr. President. This is a very simple bill. We did make an amendment to it to make a needed correction. This was brought to me by a group of assessors, and with the wide use of the internet and computers, they've asked for a way to provide electronic notification to a taxpayer upon request. And I emphasize that it is upon request, and it's also a maybe. It doesn't require, because there may be some assessors that don't want to or don't have the ability to do that. And with that, Mr. President, debate is open.
Further debate? Hearing no further debate, Senator Winder is recognized to close debate.
Thank you, Mr. President. Debate is closed.
Debate being closed. Question is, so Senate Bill 1107 is amended, passed the Senate. Secretary will call the roll.
Bear? Bayer? Bach? Brackett? Buckner Webb? Cameron? Davis? Durst? Fulcher? Getty? Guthrie? Hagedorn? Hyder? Hill? Johnson? Keogh? Lacey? Lakey? Lodge? Martin? McKenzie? Mortimer? Nonini? Nuxel? Patrick? Pierce? Rice? Schmidt? Sidaway? Stennett? Thane? Tippett? Fick? Work? Winder? Bach? Buckner-Webb? Hagedorn?
Senator Hagedorn, in the final passage, Senate Bill 1107 is amended. How would you like to be recorded?
Mortimer?
Roll call shows 33 ayes, 1 nay, 1 absent excused. Majority having voted in the affirmative. Senate Bill 1107 is amended. Pass the Senate. The correction title. Hearing none, the title is approved. Senate Bill 1107 is amended. Will be transmitted to the House. Senate now has for final consideration. House Bill 177 is amended in the Senate. The Secretary will read the bill.
In the House of Representatives, House Bill number 177, as amended in the Senate by State Affairs Committee, an act relating to the College Savings Program, to revise the powers and duties of the College Savings Program Board.
Mr. President.
Senator Getty.
Mr. President, I ask unanimous consent that further reading of House Bill 177 as amended in the Senate be dispensed with, and the Journal show it's been read a third time at length, section by section, is now before the Senate for final consideration.
Hearing no objection, Senator Getty is recognized to open debate.
Thank you, Mr. President. Fellow Senators, this particular bill deals with 529 college savings accounts. That's a vehicle we've had in this state for over a decade. It's designed to allow families to save for higher education using an Idaho tax exemption or deduction and an exemption from federal and state taxation. There are 22,000 accounts. 94% of those are to the benefit of an Idahoan. The average size of the account is $11,000. Since this plan was opened up, there have been significant changes in the way the state operates. There are 529 plans. Idaho's statute, however, does not provide the flexibility for the plan to adjust to these changes. The revisions are designed to provide the flexibility to partner with other public agencies and to reach out in a broader array of private service providers. It also allows the plan to hire staff. That's something new. The board and staff would be funded from fees paid by participants, not the general fund. Further changes address oversights and inconsistencies in the internal operations of the program. This comes to us from the Office of the Treasurer. There has been some discussion on page 3 about the provisions around procurement statutes, and it's already been determined from the Department of Purchasing that this board is outside the purchasing process. It's the same exemption that's given to the Endowment Fund Investment Board and PERSI. The language simply codifies current practice. With that, Mr. President, debate is open.
Further debate? Hearing no further debate, Senator Getty is recognized to close debate.
Thank you, Mr. President. Debate is closed.
Debate being closed, the question is, so House Bill 1177 is amended in the Senate, passed Senate. Senator Winder.
Thank you, Mr. President. I ask unanimous consent the roll call vote used for the passage of Senate Bill 1029 be now used for the passage of House Bill 177 as amended in the Senate.
Hearing no objection, roll call shows 35 ayes, no nays, 1 absent, excused. Majority haven't voted in the affirmative. House Bill 1177 is amended in the Senate. It's passed the Senate. Are there corrections to the title? Hearing none, the title is approved. House Bill 1177 is amended in the Senate. Will return to the House. Senate now is for final consideration. Senate Bill 1128. Secretary will read the bill.
In the Senate, Senate Bill number 1128 by Finance Committee, an act appropriating monies to the State Independent
Mr. President.
Senator Smith.
Mr. President, I ask unanimous consent that further reading of Senate Bill 1128 be dispensed with. In the Journal show it's been read at length, section by section, a third time, and placed before us for proper consideration.
Hearing no objection, Senator Smith is recognized to open debate.
Thank you, Mr. President. I would like to open debate on an appropriation bill, Senate Bill 1128. This is an appropriation for fiscal year 2014 for the State Independent Living Council, also known as SLIC. This budget reflects a maintenance of operations, and it is actually, even though we're maintaining operations, a 27% reduction from last year, as the agency was able to identify $156,800 of spending authority that was no longer needed. The changes from last year include employee benefit cost adjustments for a statewide cost allocation process. biggest change for the SLIC appropriation is a transparent change, not financial. Historically, the state has transferred from the general fund to the Independent Living Council. However, now, to provide better transparency and accountability of general fund dollars, this bill now changes that process, and the agency will receive general fund monies directly. This change actually has a net zero impact on the general fund. The total appropriation is $715,900 with a cap of 5 full-time equivalent positions. Mr. President, debate is open.
Debate being open. Is there further debate on Senate Bill 1128? Senator Work.
Mr. President, I just wanted to say I like the budget. I really support SILK.
Further debate? Hearing no further debate, Senator Schmidt is recognized. Closed debate.
Thank you, Mr. President. Debate is closed.
Debate being closed. Question is, so Senate Bill 1128 passed. Senate Senator Winder.
Thank you, Mr. President. I would ask unanimous consent. The roll call vote used for the passage of Senate Bill 1029 be now used for the passage of Senate Bill 1128.
Hearing no objection, roll call shows 35 ayes, no nays, 1 absent, 35 ayes, no nays, no absent, majority having voted in the affirmative. Senate Bill 1128 is passed. Senate of the correction title. Hearing none, the title is approved. Senate Bill 1128 will be transmitted to the House. And now for final consideration, Senate Bill 1129. Secretary will read the bill.
In the Senate, Senate Bill number 1129 by Finance Committee, an act appropriating monies to the Office of Species Conservation for fiscal year 2014.
Mr. President.
Senator Johnson.
Thank you, Mr. President. I ask unanimous consent that further reading of Senate Bill 1129 be dispensed with, and the journal show that it's been read the third time at length, section by section, and placed before the Senate for final consideration.
Hearing no objection, Senator Johnson is recognized. Open debate.
Thank you, Mr. President. Good Senators, this is the fiscal year 2014 appropriation for the Office of Species Conservation. The mission of the office is to coordinate policies and programs related to the conservation of threatened, endangered, and candidate species in Idaho. The bill appropriates $478,300 from the general fund, $15,000 in dedicated funds, and $12,749,500 in federal funds, for a total of $13,242,800. The bill limits the number of authorized full-time equivalent positions to 12 and provides guidance for employee compensation. The bill includes $11,000 for the increased cost of employer-paid health and environment benefits and $500 for statewide cost allocation. Statewide cost allocation accounts for costs that are allocated among all state agencies based on their usage, and is, in this case, an increase of $400 in state controller fees and $100 in state treasurer fees. Debate is open, Mr. President.
Debate. Hearing no further debate, Senator Johnson is recognized. Closed debate.
Thank you, Mr. President. I would just add that for most of the appropriations this year, it is the intent of the Finance Committee that any salary savings that may happen within an agency's budget, that they look at rewarding some of their employees with that. So thank you, Mr. President.
For the debate being closed, the question is, so Senate Bill 1129 passed the Senate. Senator Winder.
Thank you, Mr. President. I ask unanimous consent. The roll call vote used for the passage of Senate Bill 1029 be now used for the passage of Senate Bill 1129.
Hearing no objection, roll call shows 35 ayes, no nays, 1 absent. 35 ayes, no nays, no absent excused. The majority having voted in the affirmative, Senate Bill 1129 is passed. Senate. Are there corrections? Title. Hearing none, the title is approved, and Senate Bill 1129 will be transmitted to the House. Senator Davis.
Mr. President, thank you. I ask unanimous consent, Senate return to the fourth order of business.
Would you like to reorder first, Senator?
No.
Okay. Without objection, Senate return to the fourth order of business, reading communications. Senate's at the fourth order of business.
Thank you for the inquiry, Mr. President. Now I ask unanimous consent, Senate advance to the fifth order of business.
Without objection, Senate advance to the fifth order of business. Senate's at the fifth order of business.
Mr. President, Senators, if I may, personal privilege.
You may.
We will be recessing till the hour of 4:15 today. We do intend to come back and work this afternoon on some of the additional legislation in the 13th order of business. When we return, we will If we have work in the fifth order of business, we will do it. But otherwise, we intend to go to the sixth order of business and grab the legislation that was in the amending order, get those amendments on Senate bills engrossed into the legislation, move it all to the 11th order of business, and then we'll read that and put it in the second reading calendar. Then we will go to the 13th order of business and pick up the calendar where we have left off. Once we have finished our work in the 13th order of business, our intent will be to reorder the bills at that time and adjourn till Friday morning at 10 a.m. In the event that there's legislation in the 13th order of business that you believe may take some time, if you'd let us know, I'd appreciate it. It is not our intention to run past 5:30 this afternoon. Prior to recess, I ask if there are introductions or announcements.
Announcements. Senator Hill.
Mr. President, for a couple of announcements. First of all, just to remind the chairs, the committee chairs, we will have a meeting immediately upon recess up in the Majority Caucus Room. Also, we have two of our colleagues that are celebrating a birthday today. One of them is Senator Nuxall, and we didn't treat her very well today for her birthday. And for that, we apologize, but we do wish her a very happy birthday. And also, Senator Davis is celebrating his birthday today. So if you'll join me in congratulating these two good senators of ours. Thank you very much.
Senator Winder.
Thank you, Mr. President. We do have some possible 14th order work tomorrow. Again, just a reminder that if it's pressing and you want to get it done, get your amendments into the Secretary by 4 today, and we'll try and go in as briefly as possible tomorrow. If not, we'll wait probably until Tuesday to do the 14th order again. Thank you, Mr. President.
Further announcements?
As far as birthday celebrations, it was Senator Nuxall's strong desire that we not go past 5:30 as a birthday gift to her. I may be using her as a foil, so I'm really hoping that we can be done by 5:30 today and be respectful of some downtime for you. Additionally, and I don't know how many years Julie Lindy has done this now, but I'll bet it's probably about 10 years. She has baked 2 very large, from scratch, German chocolate cake that are in my office for Senator Nuxall and I, and we are hopeful that you will not compel us to singularly consume them. And so we will take one of them to the chairman's luncheon, and the other we'll put out. Perhaps the pro tem will be willing to let us have his conference room. They are historically very delicious. I have exercised good judgment thus far and will not in a few moments. Mr. President, I move that the Senate recess until the hour of 4:15 p.m. today.
Senator Stinnett.
On the motion.
Been moved and seconded that the Senate recess till 4:15 today. All in favor say aye. Aye. All opposed nay. The ayes have it. We are in recess.